Welcome to Legal Minds. I'm Dominic Simon, and this video is on offers. I'll be doing the first half of the video, and then Denzel Clarkson will cover some of the video, and then I will come back to cover the rest. So the first question is, what is an offer? An offer is an expression of willingness to contract on specified terms that will become binding once accepted. It's important to understand the difference between an offer and an invitation to treat, as the distinction will set up the rest of your essay. An invitation to treat is a demonstration of willingness to negotiate. There are several elements to an offer, the first being contractual intent, which separates it from an invitation to treat. The second being specified terms, the third being fixed terms, as in the terms mustn't be too vague, and that the offer will become binding once it's accepted. The courts take an objective approach when assessing whether or not a statement was an offer or an invitation to treat. A good way you can determine the difference is to contrast the case of Storer and Manchester City Council with the case of Gibson and Manchester City Council. In Storer, the claimant wanted to purchase a council house and received a letter back saying agreement for sale, or acceptance for sale, or something analogous to that, and that amounted to an offer on the basis that it had contractual intent. Because in applying the reasonable man test, the courts concluded that in sending that letter, the defendants had the intention to be bound by that agreement, as opposed to in Gibson, which had similar facts, except the letter the claimant received was titled "May be prepared to sell," which lacked the contractual intent that offers have, and thus was deemed to be an invitation to treat. So essentially, when determining whether or not a statement was an offer or an invitation to treat, you need to look at the conduct. You need to look at what the defendant said and did, not the intent within the defendant's own mind. Contractual intent is the difference between an offer and an invitation to treat. So the question is, did the defendant intend to be bound? There are certain presumptions that you must be aware of in order to answer a question on offers and acceptance. The first being goods on display. This includes goods on display in a self-service store and shop window, possibly goods on display in an internet advertisement, but it's not limited to just that. It can extend to things such as food on display in a buffet. The next is advertisements, then auctions, tenders, automated machines, and internet transactions. So goods on display. Are goods on display offers or invitations to treat? There are two cases on this matter. The first is Pharmaceutical Society of Great Britain and Boots Cash Chemist, which essentially provides the general principle in relation to goods on display. In this case, Boots had a certain medicine on display in their store, and the Pharmaceutical Society argued by doing so they were in breach of the Pharmacy and Poisons Act, because this particular medicine had to be under the supervision of a registered pharmacist. And their argument was that goods on display amount to an offer. And so when the customer picks the medicine up and puts it into their basket, or picks it up and puts it into their trolley, they're essentially accepting the offer. And so the medicine is not under the supervision of a registered pharmacist, and when the customer picks up the product, they accept the offer. The courts held this was not true. This is not true for several reasons. The first being that the customer has the right to pick and choose their items. If they were bound by that contract, if they accepted once they picked up the medicine and put it into their basket, then they'd be bound to purchase it. This would be deleterious to consumerism. It would be bad for consumers. The customer has the right to pick and choose what product they buy. Likewise, the seller has the right to pick and choose their customers. If goods on display were an offer, then Boots Cash Chemist would be required by law to sell the product to the customer. So what about advertisements? Are advertisements offers or invitations to treat? The case of Partridge and Crittenden establishes the general principle on advertisements, and generally they are invitations to treat. Notice how I said generally they are invitations to treat, not always. But generally they're invitations to treat, and there are essentially three reasons why. The first reason is that they lack contractual intent. The second reason is that people who make advertisements, they create the advertisements, they often don't have unlimited stock. They have limited stock, so it cannot be an offer because they cannot sell to every person that accepts. The other issue is that of multi-acceptance. This is another reason why advertisements are generally invitation to treat, because if they were offers, then they'd be in breach of contract to every person. They could not sell whatever the product is to them. They couldn't sell the product to them because they had limited stock. So those two issues intertwine. So in Partridge and Crittenden, the advertisement was along the lines of 5 bramble finches, 45s each, and that was held to be an invitation to treat.
Hi there, this is Denzel Clarkson. I'd like to say a warm welcome to everybody watching the video. It's a pleasure to be part of the channel with Dominic, and I will now be leading you on advertisements in relation to offers. So when looking at the concept of advertisements in their ability to be construed as an offer, the first thing that the courts will pay attention to is the wording of the advertisements to develop an understanding of the intentions of the parties. Now, although the following case I'm going to go into isn't binding, the American case of Lefkowitz does have implications for the law in this country. So in this following case, the defendant's advertisement was worded as free fur coats, first come, first served. And that was held to be an offer for 3 of the following reasons. Firstly of all, it demonstrates contractual intent. Secondly of all, the fact that he used the words free fur coats eliminated the problem of limited stock, and the words first come, first served also eliminated the problem of multi-acceptance. So the next idea that we'll be covering is advertisements by manufacturers. This is really interesting, as with most cases, judges are more likely to hold adverts by manufacturers as offers. This could be first seen in the Partridge case by Lord Parker, where he held that advertisements by manufacturers may be construed as offers because manufacturers are actually expected to produce a desired quantity of products. The problem of limited stock and multi-acceptance clearly do apply here. However, these comments are also not binding, as they're only open talk. So now moving on to some other interesting cases that deal with advertisements construed as offers, we have Carlisle and Carbolic Smokeball. In this case, Miss Carlisle purchased and put a deposit on a smokeball which claimed to prevent influenza. Unfortunately for her, she purchased the ball and left the deposit and was diagnosed with influenza. In the case being brought forward, defense for the smokeball company tried to claim that the offer could not be made to the world at large. This was clearly so they can excuse themselves from any liability. However, the courts held that the offer can be made to the world at large. The second defense put forward by the smokeball company was that the slogan was just a mere puff. Now this is quite interesting because this could be applied to a lot of modern day cases. This is quite obvious with manufacturers and companies such as Red Bull. Red Bull gives you wings, supposedly. But obviously, this is just a slogan and a way of advertising and marketing as opposed to actually being a contractual intention. However, the courts held in this situation that due to the deposit of £1,000, this clearly demonstrated the behavior of a contractual intention. So besides the smokeball company trying to persuade judges that they had wings, the next defense that they brought forward was that Miss Carlisle had not accepted the actual offer. However, the courts were quite strict in their ruling and actually decided that just the performance of a contract could be enough as acceptance. So moving on to the next defense, the smokeball company tried to argue that Miss Carlisle had provided no consideration. However, the courts held that there was consideration due to benefit and detriment. The benefit provided to Miss Carlisle was that she received the smokeball. However, the detriment was that she lost her money. Reversely, the smokeball company received the benefit from the publicity. However, they suffered the detriment by selling the smokeball.
Thank you, Denzel. Very thorough. Another defense that the smokeball company tried to rely on was that the time lapse to accept the offer had actually ceased, so the offer was accepted too late and the offer was no longer valid. The court held that as long as an offer had been accepted within a reasonable time frame after being made, then the offer would still be valid. Now, what amounts to a reasonable amount of time is contextual and will largely depend on the facts and circumstances of the case. So in Ramsgate Victoria Hotel, 6 months had occurred before the claimant accepted an offer made to him, and the courts held the offer had ceased to exist because 6 months exceeded the reasonable time frame to accept an offer. So if an offer for a sale of goods is made and is not accepted until 6 months later, as was the case in Ramsgate Victoria Hotel, then that will clearly exceed the reasonable time frame, as the offeror would likely have sold the goods on by then. So what about auctions? Well, there are two types of auctions. There are without reserve auctions and there are with reserve auctions. In a without reserve auction, the auctioneer is told to sell the goods to the highest bidder. And if the auctioneer does not sell the goods to the highest bidder, then he will be in breach of contract, as shown in the case of Barry and Davies. In Barry and Davies, the auctioneer was told to sell two machines without reserve, so he had to sell the machines to the highest bidder. Now, these two machines had a collective value of around £20,000, £28,000. The highest bid, however, was only £200 for each machine, so a total of £400. At a with reserve auction, the auctioneer is required to sell the item for no less than the minimum price given to him, and if he sells it for any less, then he will be in breach of contract with the owner of the goods. So what are auctions? Are they offers or invitations to treat? Pain and Cave is the leading case on this, and Pain and Cave essentially shows that the bid is an offer. When the hammer falls, that is when acceptance takes place. So therefore, items on display at an auction are an invitation to treat. We previously went over advertisements and said that the general principle on advertisements is that they are invitations to treat, that sometimes they can amount to offers. But what about advertisements of an auction? Well, again, generally they are invitations to treat, as shown in the case of Harrison Nickerson. In Harrison Nickerson, the claimant drove to an auction and to his dismay realized that the goods he was told were going to be there were not actually there. They had been withdrawn from the auction. Now, the claimant then tried to make a claim for the travel expenses, and his claim failed, on the basis that if the courts allowed such claims to be successful, then they would open up the floodgates. In simplistic terms, if the courts allowed these claims to succeed, then the auctioneer would be liable to every single person that turned up to the auction that wanted to make a bid on a particular item which wasn't there. So for public policy reasons, advertisements of an auction are generally invitations to treat. So the next thing I'm going to cover is a request for tender. What is a request for tender? Well, a request for tender is essentially where you seek particular goods or services. So you put out a request for tender. You then receive offers from other people, and then you accept the offer that you desire. And so, as shown in the case of Spencer and Harding, a request for tender is generally an invitation to treat. However, a request for tender can amount to a unilateral offer to accept the highest bid, as was the case in Harvella Investments. In this case, the first defendants put out a request for tender for shares in their company on the basis that they would accept the highest bid or the highest offer. And the claimant made the highest bid, yet the defendants chose to accept the referential bid made by the other defendant, which was a bid for $101,000 in excess of any other bid, which is what made it a referential bid. The courts examined the intentions of the parties and held that the defendant's intention was to accept a fixed bid, and therefore the defendant should have accepted the claimant's bid, as the request for tender amounted to a unilateral offer which the claimant accepted by placing the highest fixed bid. So this case essentially shows two things. Firstly, that the courts will examine the intentions of the parties, from an objective standpoint that is. And secondly, that the request for tender can amount to a unilateral offer. Furthermore, there are situations where a request for tender can amount to an implied offer to consider all tenders submitted. So in Blackpool Aero Club, the Blackpool Council put out a request for tender on the basis that they will consider all tenders submitted before the deadline. So the claimant submitted their tender, but there was a mix-up in the post, and the council didn't receive that offer until after the deadline, so they refused to consider it. The courts held that the Blackpool Council were under no obligation to accept the offer, but they had made an implied offer that they themselves will consider all tenders submitted before the deadline. And the tender had been submitted before the deadline, and so they were in breach in that sense. Okay, so what about automated machines? Automated machines, we know what they are. They present things to us like chocolate and crisps, which we put money into, that we can, we can then receive the chocolate or the crisps or the drink or whatever by putting money into the machine. So are those offers or invitations to treat? Well, this was addressed by the famous Lord Denning, every law student's favourite judge, in the case of Thornton and Shoe Lane parking. And he essentially held that they are offers. The reason being is essentially based on common sense and simple contractual principles of offers and invitations to treat. As I said earlier, offers have contractual intent. Invitations to treat are demonstrations of openness to negotiation. But you can't negotiate with an automated machine, so it cannot be an invitation to treat, and thus it's an offer. So now moving on to statements of minimum price. If you ask me what's the cheapest I would sell my phone for, and I told you £200, that would be a statement of minimum price. The question is, would my statement amount to an offer? Well, the case of Harvey and Facey shows no, it wouldn't. That's not an offer, so it's not capable of acceptance. And in this case, the defendant stated that the minimum price he would sell a plot of land for was £900, which the court held did not amount to an offer. And so you can't accept a statement of minimum price because it's not an offer, so it's not capable of acceptance. And it's essentially as simple as that. And that is the topic of offers covered. So thank you for listening. I hope it all made sense, and I hope that you gained something from it. My next video is going to be on revocation of offers, just so that you understand when and how an offer may be revoked, which is important, is actually essential for questions on offers and acceptance.